Welcome to LexAI, your AI-powered partner in mastering the law. We combine artificial intelligence, legal analysis, and jurisprudential insight to make complex legal doctrines clear, visual, and easy to understand.
All right, today we're breaking down Rule 98 of the Philippine Rules of Court, which is all about the trustees playbook. And we're going to jump right in with a classic head-scratcher, one that trips up a lot of people. Say a will creates a trust, but oops, the person who wrote it forgot to actually name a trustee. Is the whole thing just void?
So how do we even begin to answer that? Well, it all starts at the very beginning, how a trustee gets appointed in the first place. This is really the bedrock of the whole rule, so let's get into part one, the appointment process. Okay, so the very first thing you gotta know is where to file. In legalese, we call this venue. And Section 1 makes it pretty straightforward. Was the will probated here in the Philippines? If yes, you go to that same court. If no, then you follow the property, file where the assets are. And this, of course, leads us to a classic bar exam curveball. Picture this. The will gets probated in RTC Cebu, but the trust property, it's a fancy condo in Makati. So, what do you do? Where do you file the petition? Do you follow the property to Makati, or do you stick with the probate court in Cebu?
The answer is Cebu. And this is a super important point to remember. The probate court's authority comes first. It's primary. The only time you even think about the property's location is if the will wasn't probated in the Philippines. Basically, the court that signed off on the will stays in charge. Okay, so let's bring it all back to that first question we asked. If the will forgets a trustee, is the trust void? And now, we know the answer is a big resounding no. The court just steps in and appoints someone. It's a fundamental principle. A trust will not fail just because there's no trustee. And speaking of filling a vacancy, that brings up another tricky little scenario.
All right, let's say the appointed trustee passes away. And now, the executor of that trustee's personal estate is being asked to step up and take over the trust as well. Can the court actually compel them to do it? Can you be forced into that role? The law's answer is crystal clear. No way. Think about it. Being an executor for one person's estate and being a trustee for a completely separate trust are two totally different jobs. They have different duties, different responsibilities. The court can't force you to take on the second one just because you agreed to the first.
So what happens when we're dealing with a trustee who's not even in the country? Section 4 covers this, and it's really all about protecting local interests. If a foreign-appointed trustee is in charge of land here in the Philippines, our courts have the power to say, hey, you need to get a proper local appointment. And if they don't, the court can just kick them out and appoint a new local trustee. It's a powerful way our system ensures control over property within our borders.
Okay, so we've got our trustee appointed. They're officially in the role. Now what? What are they actually supposed to do? Well, let's dive into part 2, the core obligations. We're talking the bond, the duties, and yep, how they get compensated for all their hard work.
First things first, the bond. The easiest way to think of this is like a security deposit. It's an insurance policy, really, to protect the beneficiaries in case something goes wrong. Now here's the really critical part you need to remember. Even if the will itself says no bond needed, or if all the beneficiaries get together and say, we're good, waive the bond, the court can override them. At any time, the court can step in and say, nope, I want a bond in place. That just shows you the court's power to protect the trust is the ultimate authority.
And that bond guarantees 4 key promises. These are basically the 4 pillars of being a trustee. 1, they have to make a complete list, an inventory of everything in the trust. 2, they have to manage it all properly, following the law and the trust's instructions. 3, they need to provide a report card every single year and accounting under oath. And 4, when it's all over, they have to settle the accounts and hand over what's left to the right people. These are non-negotiable. They're considered baked into every bond, even if the words aren't explicitly written there.
All right, let's talk about the money. How does a trustee actually get compensated? Well, there's a clear hierarchy here. The number one source of truth is the trust document itself. If the person who created the trust already spelled out the fees, then that's the rule. End of story. But what if they forgot? What if the document says nothing about compensation?
That's when the court steps in. The court has the job of figuring out what a reasonable compensation would be. And this is a real balancing act, you know? On one hand, you want to make sure the trustee is paid fairly for their work, but on the other, you have to protect the trust from being bled dry by crazy fees. So the court acts as the referee, the final judge of what's fair.
Okay, now we get to the high-stakes stuff, the drama. What happens when things go wrong? When a trustee needs to be removed, or when a huge piece of property needs to be sold?
This is where we get into major court interventions, covered in sections 8 and 9.
So can you just fire a trustee? Well, the court can, but let me tell you, it's not a simple process. The bar is set really high. We're talking about situations where the trustee is insane or incapable of doing the job or just completely unsuitable. But even then, there's a key phrase here. The removal has to be essential for the good of the beneficiaries. It can't just be a good idea or whatever one wants. It has to be absolutely necessary. That's a tough standard to meet.
And that leads us right into another classic bar question. Let's say the beneficiaries just can't stand the trustee. There's friction, a total loss of confidence. But they can't actually prove the trustee has done anything wrong. No mismanagement, no fraud. Is just not trusting them anymore enough to get them removed by a court?
The answer, again, is a firm no. Jurisprudence is very clear on this. Just disliking the trustee or having a loss of confidence isn't going to cut it. The beneficiaries have to go a step further. They have to show the court that the relationship has gotten so bad that it's actually getting in the way of managing the trust properly. They have to prove that the administration is impaired and that removal is, there's that word again, essential.
And the last big intervention is about selling or mortgaging the trust property. This is a huge deal. A trustee can't just wake up one day and decide to sell a building, for example. The only exception is if the trust document explicitly gives them that power. If not, they have to go to court, file a petition, and get permission. And the court isn't just going to rubber stamp it. They'll only approve the sale if it's genuinely necessary or beneficial for the trust's ultimate goals. All right, that was a whirlwind tour from the very beginning of the appointment process all the way to the drastic step of removal. So let's pause and pull it all together. Let's boil this down to the absolute must-know, high-yield takeaways you need for the bar exams or for your practice. Okay, here we go. The 7 commandments of Rule 98. 1. Venue, probate court first. 2. New trustee, they get all the original powers. 3. Foreign trustee with local land, they need a local appointment. 4. The bond, it's the default rule, and the court can always demand one. 5. Fees, the trust document is king, but the court is the final arbiter if it's silent. 6. Removal, you need to prove it's essential, not just that you don't like them. And 7. Selling property, you almost always need a court order. Got it? And look, to help lock all of that in, we've got a handy little mnemonic for you. VFlex BRD. That's V for venue, F for fill vacancy, L for localize the foreign trustee, EX for exempting the bond, B for beneficiary protecting removal, and R and D for reasoned disposition or sale. VFlex BRD. It's a great little cheat code to have in your back pocket when you're under pressure. So when you zoom out and look at all of Rule 98, what's the one big idea? It's this. A trust will not fail for want of a trustee. The court is always there, acting as the ultimate guardian, the safety net. Its entire purpose in this rule is to make sure that the wishes of the person who created the trust are protected and carried out no matter what happens. And this whole discussion leaves us with one last really deep question to chew on. After seeing just how powerful the court is under Rule 98, how it can step in at pretty much any point, you have to wonder, to what extent can someone creating a trust truly limit that judicial intervention? How much can you really wall off your trust from the courts? It really gets to the heart of that constant push and pull in law between what a private person wants and what public policy demands. Definitely something to think about.